Mr. Siminya.
Good morning, Chair, and to the Commissioners. We have Mr. Surti for his evidence today.
Thank you. Mr. Surti, are you going to give your evidence under oath or affirmation?
Under oath, my lady.
Thank you. Do you swear that the evidence that you will give will be the truth, the whole truth, and nothing but the truth? If so, raise your right hand and say, "So help me God."
So help me God.
Thank you. Mr. Siminya, your witness.
Thank you, Chair. Mr. Surti, I want to propose we handle this way, that I give you what I think is a general background explaining why you are here today. But it is quite some little history, commencing about the time we transitioned as a nation from one of our wicked past to the democracy we have today. Somewhere in that chain, I will deal with you the instruments that happened and are necessary for the work of this commission. I'll go through that with you, if you don't mind.
That's fine, thank you.
All right. I have placed before you just one pager, which is a preamble to the Promotion of National Unity and Reconciliation Act. You have it in front of you?
I have it, Council.
Little longish, but I want to read it so that we know what the purpose and intention was at the time of transition.
Thank you.
So it would read, and I quote, "The preamble of the Act is to provide for the investigation and the establishment of as complete a picture as possible of the nature, causes, and extent of gross violations of human rights committed during the period from 1 March 1960 to the cut-off date contemplated in the Constitution, within or without the Republic, emanating from the conflicts of the past and the fate or whereabouts of the victims of such violations, the granting of amnesty to persons who make full disclosure of all the relevant facts relating to acts associated with a political objective committed in the course of the conflicts of the past during the said period, affording victims an opportunity to relate the violations they suffered, the taking of measures aimed at granting of reparation to, and the rehabilitation and restoration of the human and civil dignity of victims. Victims of violations of human rights, reporting to the nation about such violations and victims, the making of recommendations aimed at preventing of the commission of gross violations of human rights, and for the said purpose to provide for the establishment of a Truth and Reconciliation Commission comprising a committee on human rights violations, a committee on amnesty, and a committee on reparations and rehabilitation, and to confer certain powers on, assign certain functions to, and impose certain duties upon that commission and these committees, and to provide for matters connected therewith. You're familiar with the history giving rise and giving birth to this act, am I right?
I am indeed, thank you.
Yes, and we know it was birthed by the interim constitution of 1993.
That is correct, sir.
And its broad purpose was to create a platform, was it not, that would usher a new democratic South Africa with those conflicts of the past that had happened, am I right?
That is correct.
And it is common cause that the TRC was established and it went through its mandate, yes?
Indeed.
And in particular, it sought to say to everybody who is guilty of crimes of the past, those human rights violations, that as a nation, we can reconcile if we go through the TRC process.
That is correct.
And if those who apply for this amnesty were to furnish or 2F of the Constitution of the Republic of South Africa, 1996. The Commission is appointed to investigate matters of public and national interest concerning allegations regarding efforts or attempts having been made to stop the investigation or prosecution of Truth and Reconciliation Commission, TRC cases. Then says under 1, the Commission must, in relation to the period since 2003, inquire into, make findings, report on, and make recommendations concerning the following: guided by the Constitution, relevant legislation, policies, and guidelines. 1.1, whether, why, and to what extent and by whom efforts or attempts were made to influence, or pressure members of the South African Police Service or the National Prosecuting Authority to stop investigating or prosecuting TRC cases. Now, that is the broad purpose of this commission. It has other aspects to it. Now, there was a legal framework within which the investigation and the prosecution of those who were to be investigated for those violations of human rights, as well as those who could stand prosecutable if evidence existed. Now, I just want us to start and say, it would appear from the Constitution there were matters pertaining to investigation that would have been the police, right?
That's correct.
And there would be matters for prosecution which would be located under the NPA Act.
That's correct.
May I just go with you just at a quick glance of various instruments and or sections of law which governed that? The Constitution would say something like this under Section 179.
Pardon? Is it?
I will read it out to you.
Oh, thank you.
All right. Under 179, dealing with the prosecuting authority, it would tell us under subsection 5 that the National Director of Public Prosecutions, A, must determine with the concurrence of the cabinet member responsible for the administration of justice, and after consulting the directors of public prosecutions, prosecution policy which must be observed in the prosecution process. Now, the member responsible for the administration of justice would have been yourself.
That would be correct.
When you were the minister.
As a minister, yes.
Yes. Must issue policy directives which must be observed in the prosecution process. This is an instruction to the NDPP. Might you just at this point indicate how you understood your relationship with the NPA, which fell under justice?
Thank you, Counsel. Counsel, if you want me to reflect on the sections that you've read, I don't have the relevant section of the Constitution, but my understanding on A, for example, would be that the responsibility of developing policy would be that of the National Director of Public Prosecution.
Correct.
But he would do so in concurrence or in consultation with the minister, and after consultation, the effect thereof is in the sense that he would confer with, but does not require the concurrence with the directors. So A, the responsibility vests with the National Director of Public Prosecutions with regard to policy, unlike other provisions of the Constitution where the executive would develop and implement policy. Here, particularly in the NPA Act or in the Constitution, the reference is that it would be developed by the National Director of Public Prosecution, but he would not do so, he or she would not do so in isolation, but would do so in concurrence, in agreement with the Minister of Justice. So that would be my interpretation of that section.
And
with regard to B that you've read, the directives will be developed by the National Director of Public Prosecutions, and I imagine he would confer with his directors, but doesn't require the concurrence or the agreement of the minister. Those are the provisions of the Constitution as I would read them. As I've indicated, I've just taken notes as you've read, and that would be my interpretation, Counsel. I hope I've responded adequately to it.
And as we will discover later, your period was very short as Minister of Justice.
That is correct, Counsel. It was very short. I think it commenced on the 25th. I just got the information from one of your colleagues this morning, 25th of September 2008, and ended on the 9th of May 2009. That would be shortly after the elections, but before or at the time that a new cabinet would be constituted, because you had to have an interim period in which you would have to deal with matters should they arise during that period there. So it was a short period.
And might I ask, during that short period, did you concur to a particular prosecution policy as contemplated in the section or not?
But did I?
Would you have concurred in the relevant policy at the time that is contemplated by this section, or there was a policy already existing?
There was already a policy in existence. In fact, I was unaware of any, I was not part of any conversation or discussion with regard to policy, with regard to guidelines, with regard to directives. These came prior to my time, prior to my appointment as a Minister of Justice.
Subparagraph 6 of 179 of the Constitution would say, the cabinet member responsible for the administration of justice must exercise final responsibility over the prosecuting authority. Do you see that? You follow?
I don't see it, but I follow what you've said, Counsel.
Yes.
And I think the key word there is final responsibility. Would best with the minister. The responsible minister would be the Minister of Justice at the time, and that would have been myself during my tenure in that capacity.
Yes. And did you exercise any final responsibility?
Perhaps just to say that the way I understand it, it would be institutional responsibility. In other words, you would assume responsibility for the institution of the NPA. And from a very practical and pragmatic perspective, I could say that the NPA does not have a voice as a representative of the people, and the Minister of Justice would be a spokesperson in answering written questions, in answering verbal questions in Parliament, and Parliament would be both the National Assembly as well as the National Council of Provinces. So if questions are put about any prosecutorial matter, then the responsibility of dealing with those matters would lie with the minister, and he or she would then confer or communicate with the National Director of Public Prosecution to say this matter has been raised either in terms of a written question or in terms of a verbal question in Parliament. What would your response be in regard to this particular matter? So the minister would not be the author or the director of that particular response. It would be the National Director of Public Prosecutions, but he would almost be a conduit in terms whereof he would share that information or knowledge as it's been passed on to him. So that's my understanding of it. There's another element to it, and that is, having been in the executive, I would know that you would also be a spokesperson, in inverted commas, of the NPA in terms of resources and budgeting that is required for it to do its work. So for its prosecutorial work, for its infrastructure, its administration, its human resources, its technical resources, somebody would have to engage with Treasury, and Justice would do that as its spokesperson, as the entity that is responsible for the NPA. Until recently, it was also an administrator on behalf of the judiciary, until the judiciary now has its own power to be able to engage with Parliament in relation to its budget.
Yes, and under subparagraph 7, 179 then says to us, all other matters concerning the prosecuting authority must be determined by national legislation. Of course, that became the NPA Act, am I right?
That is correct. In fact, it's very closely aligned to the constitutional provisions.
It too would mirror image the sphere relating to the NPA and the sphere relating to the minister responsible for the NPA. Might I just read out for us what section 21 would say in relation to that? It would say, section 21, subparagraph 1, the national director shall, in accordance with section 179(5), A and B, and any other relevant section of the Constitution, A, with the concurrence of the minister and after consultation with the directors, determine prosecution policy. You see that dovetails
Yes, it does.
with the constitution in that regard.
Completely so, Council.
And issue policy directives would be sub B. Also, might I just, whilst dealing with the legislative framework for the work of the NPA, read to you Section 22, dealing with powers, duties, and functions of the National Director. It then says to us that the National Director, as the head of the prosecuting authority, shall have authority over the exercising of all powers and performance of all duties and functions conferred or imposed on or assigned to any member of the prosecuting authority by the Constitution, this Act, or any other law. Most important, says sub 2 of that. In accordance with Section 179 of the Constitution, the National Director A must determine prosecuting policy and issue policy directives as contemplated in Section 21. Again, it does this. Can I then ask if there was any separation between the NPA, which had its independence relating to prosecutorial decisions on whether to prosecute or not to prosecute? Was there any demarcation line between that and that which the minister would take final responsibility over the NPA?
You know, the final responsibility, as I understand it, and that would be my interpretation with respect, would be a broad institutional responsibility. The decision as to whether to prosecute or not to prosecute, or to decline to prosecute, would lie solely with the National Director of Public Prosecutions. The minister would have no authority or right in terms of the Constitution or the law, the NPA Act, to interfere with or determine or direct prosecution or the refusal to prosecute. That functional aspect, the functional aspect of prosecution, vests solely with the Director of Public Prosecutions. And I think it would be illegal and unethical for a minister to interfere with that process of prosecution.
Happily, there are no suggestions that you would have transgressed that line. Let me read to you Section 33, addressing ministers' final responsibility over prosecuting authority. Sub 1 says, the minister shall, for the purposes of Section 179 of the Constitution, this Act, or any other law concerning the prosecuting authority, exercise a final responsibility over the prosecution authority in accordance with the provisions of this Act. And says to enable the minister to exercise his or her final responsibility over the prosecuting authority as contemplated in Section 179 of the Constitution, the National Director shall, at the request of the minister, A, furnish the minister with information or report with regard to any case, matter, or subject dealt with by the National Director or a director in the exercise of their powers, the carrying out of their duties, and the performance of their functions. May I ask if, during the brief period of your portfolio, requested any information or a report with regard to any case, matter, or subject dealt with by the National Director? Did you request any report?
No, I did not request a report, Council.
And then says the NDPP under B must provide the minister with reasons for any decision taken by a director in the exercise of his or her powers, the carrying out of his or her duties or the performance of his or her functions, did you exercise that power at all?
No, there was no need to. It was never raised in the context of my tenure as a Minister of Justice. I never received a request from Parliament, the public, or the private sector, or anybody in relation to any aspect with regard to prosecution.
Yes. Furnish the Minister with information with regard to the prosecution policy referred to in section 21.1. Did you exercise any of those powers?
I had the authority to do so, but there was no need to do so. There was no cause for me to request that information.
Yes.
I understand the reason for it.
Yes. Submit the reports contemplated in section 34 to the Minister. Did any of that happen?
The only report that I had received was a submission from the acting National Director of Public Prosecution, Advocate Mshe, who was acting at that time. And I think it's towards the end of my tenure, it would probably be in March, that he submitted a memo to me for noting. And it dealt with the TRC cases, and he listed the cases that he had dwelt upon, indicated that he was going to re-establish a task team, and also indicated that he intended to continue with the investigation in these matters. I almost think, and I could look at the document with your permission.
I'll definitely go there, Mr. Suruti. Don't
I don't have to do so now.
I'll get with you. Sorry?
Sorry, do you want me to do that now? Or?
No, we'll get to the document.
Oh, we'll get to that. Okay, thank you very much.
We'll get to the document. But also, what 33 then says to us, arrange meetings between the Minister and members of the prosecuting authority. There would be interface of this type of meetings you would have had with the NDPP during your time?
My recollection is shortly after my appointment. When I say shortly, probably within the first month, there was a meeting with the prosecuting authority, the NDPP, and the various branches of it. You know, there was a team responsible for special investigations, etc. An agenda was drawn up by them, and a meeting was held. I almost think at the offices of the National Prosecuting Authority or at another venue. I'm not too sure, it's such a long time ago, but I do recollect such a meeting. So such a meeting had taken place, and what I can recall of this meeting are two issues, Council. One was probably a report on the proceeds of crime, the proceeds that were recovered from criminal activities. And the other was we had raised the issue of the possibility of, with the prosecuting authority, of having a dedicated court as a pilot in each province to deal with criminal matters in particular at the magistrates court, not in the regional court, but at the magistrates court, where the prosecutor, the complainant, the accused person, and the legal representative spoke an indigenous language. Given the fact that there's parity of language in the Constitution, and the reality is, and I think with respect, if I may defer to the learned Justice Commissioner Homo, who was also at one time a regional court magistrate in his past years.
Yes, but happily, those meetings had nothing to do with the TRC cases.
No, absolutely nothing.
Okay.
Absolutely nothing. I certainly, I don't have a recollection of that at all.
All right. I have also documents in your file that relate to affidavits purportedly done by yourself. I think if you go to the top of the page, the first one would be 1746.
Yes. I have it, sir.
You do have it. it says affidavit and says Mohammed Enver Surti. Would that be your name?
That would be my name, sir.
If you go further pages and you get to page 1751, you will see that name appearing in the middle of the page. Do you see that?
I see the name.
There's a signature above that line.
That is my signature, sir.
Okay. So I want us, maybe we may at the same time deal with the second affidavit, which you would find at page 1756, capital A, with the name again,
1756, you say?
1756, capital A. It is just,
Oh, it's capital A, so sorry. Oh, sorry, I was looking at 1756 and not 1756, capital A. Yes, sir, I have it.
you see the document, it too would have under 1756, capital D, middle of the page, Mohammed Enver Surti, and a signature which you will recognize.
I recognize it as my signature,
There
Council.
we go. All right. Now, of course, the evidence leaders directed a request for information of whatever nature in relation to the terms of reference of the commission.
Pardon?
I'm saying we sent you a request for information, and in response, you gave us the affidavit to which you have now recognized.
That is
Can
correct.
we go back to that first affidavit because it deals with specific issues?
That is correct, Council.
Now, in this affidavit, you tell us your background, that you would have started as a practicing attorney in Rustenburg in 1977. Is that right?
That is correct.
And you later then retired from legal practice to join Parliament
That is correct.
and occupied various engagements in your standing as a member of Parliament. You deal with those in paragraph 4.
That is correct.
For what it is worth, can you just read it into the record?
Shall I read into paragraph 4?
Paragraph 4. Mhm.
Paragraph 4. In 1994, I retired from legal practice after being elected to represent the Northwest Province in the Senate. I served as the provincial whip of the African National Congress and as a member of the select committees on security and justice and cooperative governance and public administration. These committees exercise oversight over defense, intelligence, local government, and traditional affairs. Following the adoption of the final constitution in 1996, I continued in this role in the National Council of Provinces.
Yes, and then you track what happened in 1994 and 1996 with the theme committee 4 of the Constitutional Assembly. That you deal with under paragraph 5, right?
That's correct.
It would have later in your life some relevance relating to justice.
That would be so, because the task I was assigned with was to be negotiator of Bill of Rights on behalf of the African National Congress, and that is quite central to our system of justice.
Yes, but coming forward, I look under paragraph 7 that during the second Democratic Parliament, this is now June of 1999 and 13 April 2004, you were elected to the National Assembly. After 2 weeks, you were deployed and elected as Chief Whip of the NCOP, chaired by former Minister Naledi Pandor. That's what you say is
That
part
is
of the
correct, sir.
background. Yeah. And during the third Democratic Parliament, 14 April 2004 to 21 April 2009, you are appointed the Deputy Minister of Education under the Minister Pandor. in October 2008, following the resignation of President Thabo Mbeki, President Halima Motlanthe appointed you as Minister of Justice and Constitutional Development. In that capacity, you served until May 2009.
That is correct, sir.
And during the 4th and 5th Democratic Parliament, you served as Deputy Minister of Basic Education for both terms, under Minister Angie Motshekga until your retirement from Parliament.
That is correct.
And then you deal with a document we brought to your attention under paragraph 10. The purpose of this affidavit, you say, is in response to a request for assistance from the Commission dated 23 April 2026, requiring you to explain a handwritten note made by yourself on a memorandum prepared by the then acting National Director of Public Prosecutions, NDPP, Mr. Mokotedi Mche, SC, dated 17 February 2009. Let me invite you to that document, which you will find the top of the page being 1752. Can you see the document?
I see it. It's 1752. That's correct, Council.
Yes, you recognize the document now.
I recognize the document.
It would have been directed by Mpie in his acting National Director of Public Prosecutions. You notice that?
I do.
And you did have, it is dated 17 February 2009 and addressed to M.E. Surti MP, Minister of Justice and Constitutional Development. You see, that's what it says.
I see.
It tells the reader the purpose of this memorandum was to inform the minister of Mpie's intention to reconvene the TRC task team and to advise him of matters relating thereto. Is there any significance that its purpose is said to be informing the minister?
Well, I've indicated that in my affidavit to Council. This is to provide, you have broadly two categories of submissions that you would receive as a minister. One is for consideration or decision. That would be a memorandum where the recommendations would be made and you have to either approve or decline. And you would generally make comments as to why you would do one or the other. The other is, as in this case here, is really for noting. The authority to do what the acting Director of Public Prosecution had done was with him. He had the institutional, legal, and constitutional authority to do so. He would provide a report to the minister indicating his intentions. That is an interaction that would take place. The minister, after all, has final responsibility and ought to know what is happening in the institution. So it's a courtesy, and a very important one at that. It basically brings to the attention of the minister the intention of the National Director of Public Prosecution, and he sets out his reasons for doing so, and he sets out in the memorandum the cases that are on hand at present, as he says so in paragraph 3.4, and these are very high profile and important cases which we had heard of. It was in the public discourse anyway, and part of what we had learned about people who were affected. And then there are comments. Comments of, you will notice from the memorandum, Council.
Before we go there.
Oh, we'll go there. I'm sorry.
Before we go there.
Let me stop there.
Okay. I was just saying, even in its own language, it talks about a briefing where you expected the minister to make any decision in relation to this briefing.
The nature of the document does not lend itself to one where the minister is to make a decision. It's really a report that is provided and also information that is given in relation to the action that is going to be taken by the acting director of public prosecution in relation to TRC investigations and prosecutions.
If you go back to your affidavit under paragraph 11, you react to this document. It would be just 1747 of your first affidavit.
Yes,
Paragraph
I see
11.
paragraph 11, sir.
Yes. I read it for your reaction and response. The request arises from an email addressed to the Commission on 15 October 2025, in which I stated that I had no engagement whatsoever with either the National Prosecuting Authority, NPA, or the South African Police Services concerning the prosecution of TRC matters.
That is correct.
That's how it reads.
That is what I had indicated to you at the outset, Council, until the memorandum was submitted to me just a long time ago. I obviously told you that, look, you know, it's certainly a document that had been sent to me. My signature appears on it, and the comments that are there are indeed in my handwriting. I did not dispute that.
Yes,
but merely
continue.
to say that in terms of verbal exchangement or discussions, there was no discussion between Advocate Mshe and myself, or with anybody from the South African Police Service and myself in relation to TRC matters. But I certainly accept and acknowledge that this memorandum was submitted to me.
You do say that because against paragraph 12 you say, at the outset I place on record that when I was first approached by the evidence leader of the Commission, Ismail Semenya, and requested to provide any information in your possession relevant to the Commission's inquiry into alleged political interference in the investigation and prosecution of TRC matters, I did not recall having commented on the memorandum, you say. Correct?
Yes, sir. I certainly had no recollection of the memorandum at the time. And
Yes.
had it not been for you providing me with a document, I would have been unaware.
For completeness of your evidence, you also continue to say, I accordingly informed Mr. Semenya that I had not engaged with the NPA or SAPS regarding TRC prosecutions, and indicated that all official records would be in the custody of the Department of Justice and Constitutional Development.
That is indeed so, because when you leave your office, you don't take any documents with you. They are left in the custody of the Department of Justice, and that would be the reality.
And you tell us on 23 April 2026, you received a further communication from Mr. Semenya touching a memorandum prepared by the then acting NDPP, Mr. Mpie. The memorandum was received by the DG, Mr. Menzi Simelane, on 5 March 2009 and passed on to the Office of the Deputy Minister of Justice and Constitutional Affairs, Deputy Minister Johnny D. Lange, on 11 March 2009. It was transmitted to your office on 17 March 2009 for noting. You make that point. A copy is the one that we have just handled now.
That is
Right.
correct, sir.
And you say, after having considered the memorandum together with Mshe's evidence to this commission on 7 April 2026, I can confirm that the memorandum is authentic and the handwritten note attributed to me is indeed mine. My failure initially to recall the memorandum was attributable solely to the passage of time and the fact that at the time, the memorandum did not appear to me to involve anything unusual or contentious. But then you say, under that heading, I state categorically that during my brief tenure as minister, I neither interfered with, influenced, or suppressed any investigation or prosecution, including investigation or prosecution relating to the TRC matters.
That is indeed so.
All right. Then you say to us under paragraph 17, if you read it into the record.
May
If
I?
you read it into the record.
It is important to distinguish between the memoranda submitted for approval and those submitted merely for noting. This memorandum falls into the latter category. Its purpose was not to seek my direction or approval, but to inform me of the acting NDPP's intention to reconvene the TRC task team.
Yes.
Do you want me to continue, Councillor?
Please do.
The memorandum recorded that the work of the TRC task team had been delayed, amongst other reasons, by the establishment of the Jinwala Commission. It further recorded that the Jinwala Commission had made no findings affecting the functioning of the task team. The memorandum also referred to a number of high-profile matters requiring investigations. It recorded that most of these matters required investigation by the South African Police Service and noted that guidelines formulated during my predecessor's tenure had been declared unconstitutional. Although an appeal against that decision was pending, the memorandum expressly recorded that there was no impediment to investigating proceedings. Given the sensitivity, shall I continue?
Yes, please
Council?
do.
Given the sensitivity of the matters concerned, the memorandum proposed that a risk assessment be conducted by the National Intelligence Agency.
And under 21?
Under 21, as was the established process within the Department of Justice and Constitutional Development at the time, the memorandum was routed through the Director General and Deputy Minister before being submitted to me. That process ensured that I had the benefit of their respective views and comments before considering the memorandum. That would apply to all memoranda that were submitted to me. It would always receive the attention of the DG first, and before it comes to me, I had directed that my Deputy Minister would look at the memorandum and make any comments if he wishes to do so, so that I have the benefit of their perspectives or points of view.
And relevant to the interministerial committee, you talk about that in the following paragraph, right?
Yes, the DG at that time, Mr. Simelani, recommended that the matter first be discussed within the interministerial committee so that the acting NDPP could be guided in relation to the NPA's mandate. The IMC comprised the ministers responsible for justice and constitutional development, police and intelligence.
Yes. And then you say under 24, although no approval was required from me, I nonetheless had to apply my mind to the contents of the memorandum given the significance of the matters addressed in it. It was both customary and appropriate that I be informed of developments concerning matters of this nature.
That is indeed correct, and I couldn't be dismissive of such an important matter, so I would apply my mind to an important matter, and also given the reality that there were comments both from the Director General as well as the Deputy Minister. But it's an important matter that I wouldn't regard as trivial or simply note without making a comment on. I almost think, and I speak subject to correction, if you could just bear with me for a moment, I almost think that the Acting Director of Public Prosecution almost certain comments.
If you go to page 1756, you will find something written in manuscript.
Yes.
1756,
Yes.
under your name, there is your manuscript comment with an exclamation mark.
Yes, the comment there is investigations must proceed with an exclamation mark. It's an emphatic suggestion or request that please continue with the investigations.
So nobody can seriously accuse you of having attempted or interfered with the investigations and or prosecutions. Am I right?
Not at that time or any other time. It's just not in my nature to interfere with prosecutorial work, you know. So it's
Yeah. And you say in your statement, the decision whether to prosecute or not to prosecute still remained the province exclusively that of the NPA.
well, it is. In fact, that's what the deputy minister says, and that's why I endorse his sentiment. He says that the decision to prosecute or not to prosecute lies with the National Director of Public Prosecution. So I don't know what his language was, but that was one point that he made, and I endorse that fully, because I mean, how it would be inappropriate, it would be illegal and unconstitutional for a minister to direct a prosecutor, National Director of Public Prosecutions, to prosecute or decline to prosecute. It's something that power vests in him or her, as the case might be.
Of course, the MPA would criminalize such conduct under Section 41.
It would, yes.
Can I go with you to paragraph 30 of your statement where it reads, upon my appointment as minister, I was also required to address the findings of the Ginuala Commission concerning the conduct of the then Director General. Given the seriousness of those findings, I propose that the matter be referred to the Public Service Commission for investigation. My term of office ended before that process could be finalized. Am I right?
That is correct, sir.
Okay. Except for what is reflected in the memorandum itself, I did not recall any engagement with the NPA or SAPS concerning TRC prosecutions. But you do reiterate, during your tenure as minister, you say you did not interfere with, influence, or suppress any investigation or prosecution, including those relating to the TRC matters. Have we covered that affidavit?
That is indeed so, sir.
We have also dealt with the memorandum by the acting National Director of Public Prosecutions at the time, Mr. Mpie. Right? I now invite you to look at page 1756A, which you confirmed to be your statement. And you say you want to make a supplementary affidavit in response to a further request by the evidence leaders that you address implications of section 179.4 read with 179.6 of the Constitution and explain your understanding of the constitutional responsibilities that resided with the prosecuting authority in the light of Commission's evidence concerning absence of TRC-related prosecutions during the period in question, right?
That's correct. Also.
Now, if you page over, of course, under 5, you say, what you do say here enjoys the benefit of legal advice you would have received. And then you explain the process by which the memorandum came before you, and we have dealt with that. Am I right?
That is correct, sir.
Under 7, you say, I explained that the memorandum did not seek any decision. We have gone through that part. Am I right?
That is correct.
And you further explained that your comments reflected your views that investigations should continue, that decisions whether to prosecute remained the responsibility of the NPA, and that coordination through interministerial committee could appropriately be considered.
That is correct.
And you confirm that you neither interfered with or influenced any investigation or prosecution including those relating to the TRC matters. Am I right?
That is correct.
And then you deal with section 179.4, which we touched on earlier in your evidence. Am I right to see
That is correct.
Yeah. You go over page, you deal with 179.6, you deal with 179.6 of the Constitution, and can you read what you say in paragraph 13?
Paragraph 13, I stress that I do not recall any concern regarding an alleged failure to prosecute TRC matters raised with me by the NDPP, any member of the prosecuting authority, the Director General, Cabinet, Parliament, or any person, nor do I recall receiving any report suggesting that prosecutions which ought to have been instituted were not proceeding. That's my recollection, you know.
Continue to read 14 for us.
14, apart from the memorandum referred to in my principal affidavit, I cannot recall any discussion, briefing, or request was brought to my attention concerning the progress of TRC-related prosecutions or the absence of such prosecutions.
And you conclude your affidavit supplementary
The
in
absence,
paragraph 15.
Oh, sorry, shall I read that?
Yes,
Yes.
please.
The absence of TRC-related prosecutions was never presented to me as an issue requiring ministerial attention or intervention. I therefore had no occasion to inquire into why particular prosecutions had not been instituted. Had concerns of that nature been brought to my attention, I would have referred them to the NDPP at the time and asked for a report.
And that concludes your evidence in chief, Mr. Surti, am I right?
That is correct, sir.
Chair, that is the evidence.
Thank you. Mr. Kuala.
Good morning, Chairperson. We do not have questions for this witness.
Thank you. Ms. Kesri. Thank you. Ms. Mchizane.
Thank you, Chair. Yes, I do have only just one question.
Switch on the other microphone, please. Yes.
Good morning, Mr. Sorti. I would just like to find out from paragraph 28 of the first affidavit. It is your testimony that the IMC proposed discussion did not take place. The discussion proposed by Advocate Simelane did not take place. I would just like to find out if, since you were in support of the contents of the memorandum proposed by Advocate Mshe, did you have any further interactions with him or discussions regarding the proposed memorandum?
No, there was no discussion or interaction with him, Council. If you look at the memorandum itself, it's towards the end of March. We were almost on the cusp of an election that was taking place, and that's probably the reason why he didn't submit the intelligence report to me or come back to me. I'm speculating now, but I'm saying that the elections were imminent. I think they were announced in February that year, and as ministers, you were almost closing. You had to submit your final report, I think by the end of March, if I'm not mistaken. It's a long time ago. And there was not really an opportunity to follow up on this particular matter. So the IMC did not take place. It's usually arranged by the Director General. So even IEC has to take place. And I'd indicate in the memorandum that I was not averse to it, that indeed it could take place. It would depend obviously on the availability of your colleagues in the security cluster. I can't now speculate as to why it didn't take place, whether efforts had been made, and I think the best person who would be able to respond to that would be the Director General, Menzi Simelane, at the time. But I certainly do not recollect having a meeting for that particular purpose.
Okay. Thank you. Thank you, Mr. Chodi.
Thank you.
Chair.
Thank you. Am I missing anyone? Mr. Vani?
Thank you, Chair. Just a few questions by way of clarification. Mr. Surtee, firstly, thanks for taking the time to come to the Commission to assist us. We make no allegations against you from the perspective of the families. You've denied categorically being involved in any political interference in the TRC cases. We do not dispute what you say. We also note that I'll just wait for this.
Yes.
We also note that you were only Minister of Justice for around 7 months, so you didn't have too much time to really fulfill that role meaningfully, which can't be done in 7 months. So I just want to draw your attention to a few paragraphs in your statement, and these deal with that memorandum of the 17th of February 2009. I'm going to refer to paragraphs 18, 19, and 20. So that starts on page 1749 of your bundle. And you point out at paragraph 18, and making reference to paragraph 2.2 of that memorandum, that the investigations into the TRC matters could not continue, given that the task team had not sat and there were matters tabled before the Ginwala Commission. That's essentially what paragraph 2.2 of the memo says. Was it your understanding that because of the work of the Ginwala Commission, that the investigations into the TRC matters could not continue?
Thank you, Advocate Vani. Firstly, thank you for your kind words and for understanding that my tenure was very, very brief. No, what I indicated here on paragraph 18 was that this is what the memorandum stated. It was not my view. I certainly haven't looked at it closely enough to say. In fact, when I read the report, I had to read the Ginwala report in relation to the Director General and its comments. There was nothing, no reflection in the report that I had read. And it's a long time ago. We suggested that work had to be suspended or stayed at the time. So I have no knowledge of that being a directive or a consequence of the Ginwala report being initiated. So let's put it this way, I don't have sufficient knowledge on that particular matter, but it's not my view. I'm merely conveying in paragraph 18 the view of the Advocate Miché as he submitted the memorandum to me.
Yes, no, totally understood. From the perspective of the families, their view would be, well, even though a commission of inquiry is sitting, looking into the suitability of Advocate Bacoli, criminal investigations through the investigations of the SAPs could continue nonetheless.
Well, there's nothing from where I sit. I mean, I don't have all the facts at that particular point in time, for it's difficult to respond. But I mean, investigations must continue because the principal categories are those who have not applied for amnesty, who are not granted amnesty, and those who have not applied for. So investigations, they would be culpable or liable for prosecution unless there was legislation or other laws that prevented that. So there's nothing that would prevent investigations, and I think that probably is the reason why I was so emphatic to say investigations must continue. That's probably the reason. It's difficult to consider now, after 17 years, precisely what are the factors that gave rise to a particular comment of that nature there, but I would imagine that would be one of them.
Yes, and as you mentioned, you added the exclamation point to emphasize that.
Oh, well, that's emphatic, yes. I mean, that was my emphatic view, that investigations must continue, because you couldn't wait for an IMC or even a discussion or a report before. That shouldn't hold back the investigations. That was my emphatic view at the time.
Yes, indeed. So let's then turn to your paragraph 19. And this, I believe, is a comment on paragraph 5 of the memo. And here you indicate that the memo referred to high-profile matters requiring investigation. It recorded that most of those matters required investigation by the SAPS, and noted that guidelines formulated during my predecessor's tenure have been declared unconstitutional. Let's just pause there. You've noted that the matters required investigation. At that time, were you aware of the struggles of the NPA to get investigators between 2003 and around 2010?
Advocate Vani, to be honest, I was not. And then I could explain why I was not. I was the Deputy Minister of Education, and education at that time involved both higher education and basic education. And at the time of my appointment, I was seized with many tasks. And if I could just give you an understanding of some of them, is we had to develop legislation around ICT colleges. We had to finalize norms and standards for districts. We had to proceed with the finalization of workbooks for promoting literacy and numeracy, and a range of other urgent matters. And then there was the Education Laws Amendment Act, and one of the delegated responsibilities of mine as a Deputy Minister was to deal with all legislative matters in the Department of Education. So it was towards the end of our phase, and we were so busy and so engaged in that particular aspect. It involved curriculum, interactions, etc. I really didn't look at security or justice matters at all. So I can only apologize that I didn't do so, but those were the realities. So when I got appointed as Minister of Justice, I mean, it was without warning, it was quite sudden, and I had shared with Councillor Semenya that I had two records. One is the longest-serving Deputy Minister of Education, and the second is the shortest-serving Minister of Justice. I mean, that was the reality, and you know, it was a huge task in education. Not to say that it was any lesser in justice. It was huge, given the limited time that we had over there.
Yes, and you've already indicated that while you were Minister of Justice, I think it was only this memo that brought the TRC cases to your attention.
That was the only memo that I had received. To my knowledge, I mean, it's a long time ago, but you know, I inquired from the Department of Justice whether there's any other documentation, and they weren't able to submit. And that I did right at the outset to say, if there's anything else, please bring it to my attention. I have received no other such documentation.
Well, we're not aware of any.
Neither am I.
Now, in that same paragraph, you indicate that the guidelines were declared unconstitutional, and although an appeal against that decision was pending, the memorandum expressly recorded that there was no impediment to investigations proceeding. That appeal ultimately wasn't taken forward. A leave to appeal was lodged, it was dismissed, and then I understand there were discussions around petitioning the SCA, but that never went ahead. Do you recall that?
No, it was not during my time, because when I received the memorandum, it was in March. I think I responded to it towards the end of March, and the elections were just around the corner. So obviously, I could state that I'm having practiced as a lawyer. I would know that appeals take an inordinately long time before you even get a date for sit down to argue the appeal, and probably. I'm saying probably, at the time, one of the I would not regard that as a reason to hold back your investigations, because I mean you would basically feed into dilatory or delayed action in this matter here. But I certainly wasn't aware of it, and if I was in office, I would probably have asked for the notice of appeal, because it happened before my time, and to find out, let me get more information about this particular aspect. But
Yes, indeed. And Advocate Mshere says there's no reason why investigations can't continue notwithstanding the appeal.
well, I agreed with him and I
Yeah,
supported it.
you said so as well. But I just want to put to you what the NPA annual report for 2008 and 2009, what that said about the appeal. It mentioned that the TRC guidelines were declared unconstitutional, and a decision to appeal will be made in early 2009. And then it says a further delay in the prosecution of cases emanating from the TRC process is therefore inevitable.
I'm sorry to interrupt. Can you perhaps get a reference for that?
Yes, Chair. The reference is in Bundle 1 at page 116. 116. So essentially the NPA said in the annual report for 2008 and 2009 that because of the appeal, the prosecution of cases from the TRC would be delayed, and that was inevitable. So it seemed as if there was something of a mismatch.
I really can't comment on that. You know, it's just that my view has been the view that if you note an appeal, it doesn't mean that you're going to stay investigations, that they should continue. I mean, you know, you can't even predict or foresee the outcome of an appeal. And as I said, I was not the author of the decision regarding the appeal, and I had insufficient knowledge regarding the content of the matter in respect of policy or guidelines or directives to be able to make a decision.
Thank you, and noted.
Thank you.
And then if we turn to your paragraph 20, where you state that given the sensitivity of the matters concerned, and then proposed that a risk assessment be conducted from the National Intelligence Agency, and the paragraph in the memo where it says that, it's paragraph 6, so given the unique circumstances surrounding TRC cases, NIA has been requested to compile a threat analysis of the risks attached to such investigations. Can I ask, did you agree that there was a need to assess the risks and why this should be done by NIA and not perhaps crime intelligence of SAPS?
What I receive, what I'm reflecting on is really what has been indicated by Advocate Mshere. So it's not as a result of my request or initiative. It's something that he said he would submit. He was unable to do so, and I think probably more than likely it's because of the elections that had come up. But I certainly did not receive any report, nor would I go to the President and raise the matter with him unless I had information which suggested otherwise, that there would be a threat, national interest, whatever the case might be. But I mean, I really had no report. I had no sense of what the threat was, what the threats were, or what the analysis was at the time.
Noted, thank you.
Sorry, I sound ignorant, but those were the realities.
Certainly no need to apologize.
Thank you.
Perhaps we can then turn to your references to the handwritten notes on that memo. And this is from paragraph 22 onwards, and the handwritten notes are on page 175 1755 to 1756 of the memorandum. And let's perhaps start with the first one, which is Mr. Simelani's handwritten note, which is right under the signature of Advocate Mshere. And perhaps I'll just read into the record what we understand that handwritten note to say. He writes, "It may be useful that the Minister first discuss these matters with the IMC ministers so that the acting NDPP can be advised how to proceed, especially on what the mandate of the NPA is on these matters." Is that also your reading?
Well, that's what he had written there, yes.
Yeah.
But that's not.
It's just sometimes difficult to read handwriting. So I
Yes.
just wanted to
That's how I read it as well, and that's the reason for my comment.
We note that Mr. Simelani says that the ministers on the interministerial committee he says it's useful that the minister first discusses it with those ministers so that the acting NDPP can be advised how to proceed in respect of the cases listed, and especially on what the mandate of the NPA is on these matters. Did you ask, why would a senior prosecutor like Advocate Mshere need to be advised on what the mandate of the NPA is?
I don't know. I don't know. I can't speak on his behalf in regard to that. I could only speak about the value of an IMC. It wouldn't be a condition antecedent to my comment. In other words, I didn't have to meet the IMC before I made a decision to say continue with the investigations. But it would be beneficial from a perspective that if they are aware of the fact that a task SIP has been set up, that is being activated, they could basically ensure that progress is made more swiftly. So, I mean, if I could give you an example of, just maybe an example or two of IMCs where I was involved, in terms of early childhood development in education, for example, preschool was with the Department of Social Development. Health was involved, education was involved, and social development. We then transferred, ultimately, as a result of interaction in the IMC, to grade arts to the Department of Education, which was previously with social development. It makes great sense because our preschool children are now going to school. Had that interaction not taken place, you would still have had a contestation between social development on the one hand and education on the other. And that's one example. Another example of the value and benefit of interaction is before the elections, there were huge problems in KwaZulu-Natal in the Ulundi area, especially with no-go areas. And you were probably aware of it at the time. And there was a newly appointed Minister of Intelligence, Siyabonga Kwele. I was the Minister of Justice, and the National Commissioner at that time was the former Minister of Police, Becky Pele. We met in and Advocate Mshere, as well as the National Director of Prosecution, to say, how do we deal with this matter here? Because you can't have no-go areas during an election period. And the decision was that we would have a dedicated court with dedicated prosecutor to deal with the matter. So the moment police would be there, they would have top-notch police to basically ensure that when there's a transgression, arrest has taken place, prosecutions are not awaiting. These. We had a dedicated court for that matter. And the result of that interaction is we went through an election and there were no problems in the northern part of KwaZulu-Natal. So I knew what the value and benefit of an IMC was, but it certainly would not be something that would be a condition antecedent to investigations continued. So I had no difficulty with an IMC discussion, but I certainly didn't want it. A discussion did not have to precede my view that investigation should continue, Advocate Vani. That would be my comment.
And thanks for that explanation. It's helpful and insightful. So I understand that an IMC can be useful when you have to deal with structural issues.
Absolutely.
You need to perhaps develop a policy and approach. Perhaps you need to raise budget and resources. The collaboration between ministries is important. But given that, that's why we're a bit puzzled that individual cases would be going to the IMC.
No. That was not my understanding, and that's not my view, emphatically. That we would not give a mandate to the prosecutor to decide on whether to prosecute or not, or decline to prosecute or to investigate or not for the police service. We would not interfere in that particular process.
Yes.
I certainly wouldn't be party to such a discussion.
And indeed, I think you underscore that in your supplementary affidavit. It's at 1756C, paragraph 12. Where you deal with section 1796 of the Constitution, which talks about the minister exercising final responsibility over the prosecuting authority. And you state, I do not understand section 1796 to extend to directing prosecutors whether to investigate and prosecute or decline to prosecute individual matters. Decisions concerning individual investigations and prosecutions fall within the exclusive competence of the NPA, which again is why we are a little concerned that these cases were referred to the IMC and potentially the President as well.
Sorry, Chair, I'm sorry to interrupt. Can you also then perhaps give us a reference where, in the evidence, where they said that these cases were taken to the IMC, just for our own?
Yes, certainly. It's in the handwritten notes that we've just made reference to, page 1756, or bottom of 1755, and then 1756 of Mr. Soti's bundle. Mr. Soti, do you understand our concern around referring individual cases to a ministerial committee?
No, I don't think, I didn't, I certainly, when the DG suggested a referral to the IMC, my understanding would be that basically to draw the attention to the fact that you've got a task team that has been re-established by the NDPP. Obviously, your police service is required to assist in that particular process because they are principally responsible for investigations. And it would be nice if intelligence, the police service, and the prosecuting authority work together in order to achieve an outcome that gives rise to prosecution that should take place. So that is my view. It's certainly not my view that it is to give a mandate for individual cases to be prosecuted or not. That would definitely not be my view.
Thank you. Let's then turn to the handwritten note of Deputy Minister Delanga, which, as you point out in your paragraph 23, is not entirely legible. So I want to read you our sort of interpretation of his handwriting. And this is on page 1756. He writes, I can't find fault with the approach proposed. In fact, in law, NDPP must proceed with prosecutions or not prosecute. To ensure this does not take place in isolation, the task team was established as part of prosecuting policy. As this is a sensitive matter, I agree with urgent consultations with the NSC and the President. do you perhaps know why he felt this, the President needed to be consulted?
I don't know. What I could say is Advocate Delanga was my deputy minister, and a very competent and efficient one at that, I must say, had served in the previous term as deputy minister to my predecessor. He might have had information or knowledge that I was totally unaware of that gave rise to it. What I agreed with, the sentiment, there are two sentiments that I agreed with, and I say that quite emphatically. The first is that the decisions to prosecute or not to prosecute vested solely with the NDPP. It's not a decision of government, or the executive, or any external force. It's really, that authority is given to them through the Constitution and the provisions of the NPA, which, as Senior Counsel had indicated, is mirrored in the Act itself. So that's the one element. The second element was basically the value of the interministerial task team. And here again, I've first had existential experience of the benefits of working, of these groups working together in a range of matters where they work together, whether it's in terms of alcohol abuse, which involve health, education, and social development, whether it's in terms of children's well-being and welfare, which involve those task teams of this nature here, where you have a collective end in mind which you share, certainly are beneficial. So I think what Advocate Delanga was saying out here is that there are huge and enormous benefits in having a task team look at this over here, because there are forensic aspects, there are investigative aspects, and a range of things. And basically they could feed off each other in terms of ensuring that there is sound prosecution. So I have no difficulty with that. With regard to the last part, I must say it was not clear in terms of the sensitivity. I saw sensitivity, and you can look at the document here as I see it in the folder. There are words that are missing. So I don't know precisely what was meant over there. But my position is simply this, that I'm not going to go to the President and raise an issue with the President without having some factual, substantive information to say that, President, here is a reason why we should stop investigation or reflect on this matter. I did not do so. I did not receive the intelligence report. I had no information about its sensitivity, and in my opinion, respectful opinion, it was no reason for the investigations not to continue, and to continue with speed, actually, because it had been a long time, So that's my perspective, and that's my understanding. My endorsement was on those 2 points: the value of and I support that, and I continue to support that, of a task team, which would be beneficial, and also the fact that the prosecuting authority is the authority to make decisions on individual cases, and it's not an executive authority or a collective authority. It vests solely with the National Director of Public Prosecutions, and I have no doubt in my mind that would be the view of Advocate Delanga, that in terms of his interpretation of policy and in terms of the Constitution, it would be very emphatic that the decisions to prosecute or not to prosecute in individual cases lies not with the executive or any other person or institution, but solely with the National Director of Public Prosecutions. I'm speaking on his behalf, but I do so on the basis of the fact that we've worked together for a long time as members of Parliament and his colleagues.
Thank you, Mr. Setu. And perhaps, I think that particular question around this, where he says, as this is a sensitive matter, I agree with urgent consultation with the NSC and President. I think that's really a question that must be put to Mr. Delanga, and perhaps we will approach the evidence leaders in that regard. All right, let's just move on. I just want to see if there's anything else arising from the memo. Perhaps if I can draw your attention to paragraph 3.3 of the memorandum. the advocate Michelle writes, no request to investigate TRC matters have been received since November 2007, and it is anticipated that once the matters on hand have been dealt with, that the chapter on these cases may be closed. I'd like your comment on that statement where he says, well, we haven't received any further requests to investigate since November 2007, and then once the matters on hand have been dealt with, I'm assuming he's referring to the 9 matters listed, then the cases, then the chapter on these cases may be closed. I ask because we know that, we don't know the exact figure, but it was a few hundred, perhaps between 300 and 400 cases that were referred by the TRC to the NPA. So do you have any comment on what Advocate Mshere is suggesting, that they haven't got any further requests? Once they've dealt with these matters, then this chapter can be closed?
I really can't comment on the veracity of his statement. I don't know where he would have got his information from, and I certainly wasn't aware of. I had not received a briefing either from my predecessor because of the sudden movement. She had moved to public service and administration. I had moved to justice, or from anybody in relation to the TRC matter. So I can't really say it is within my knowledge. It's not within my knowledge, and I would not like to comment on that. I'm not disputing what you're saying, but I really would not want to comment on something that I'm unaware of and I have no information on.
You would understand the perspective of the families that there were a large number of matters, aside from these 9, involving many serious crimes such as murder and kidnapping, which don't prescribe. And from their perspective, they would have expected the authorities to continue.
I certainly have empathy for the victims and the families of the victims of these nefarious crimes. One has to have that compassion and understanding. But what I'm saying is that I can't comment on the factual or the veracity or the authenticity of that information there, because I don't have any direct knowledge of that, Advocate Vani. So it's not to dispute the rights or the sensitivities of the families. I share in the compassion. I know I'm aware of your commitment to that particular task, and I empathize. So emotionally, I do. But I'm speaking specifically now about the information there. I don't know.
Thank you, Mr. Sethi. Your sentiments I appreciate it.
Welcome.
If we can then turn to paragraph 3.4, and the other 9 matters are listed.
3.4.
Paragraph 3.4, it lists several matters such as Pepco 3, Lebowski, Craddock 4, Nakatula Simelani, the Heidelberg Tavern, St. James massacres, and a few others. Murder of Rick Turner, allegations against General Barcy Smith. Now, as far as we're aware, all these cases remain unresolved. We are aware that 1 or 2 of them have been enrolled, although they haven't been finalized, such as Nakatula Simelani. We're also aware, Mr. Sethi, that between 2007 and 2016, there were no TRC cases, such as inquests or prosecutions, that went ahead. So perhaps I can ask for your comment on the fact that, as we stand here today, these 9 matters still remain unresolved. And in that period between 2007 and 2016, which included your 7 months. As I mentioned, we don't hold any of that against you personally. But do you have a comment on the fact that so few of these cases have been taken forward over the years?
It's very difficult to comment. I can agree that it's a long time, a long period of time. I don't know what the circumstances were during my predecessor's time or my successor's time. What I do know is that indeed ministers have been called to testify, and ministers of police and ministers of justice and directors general. And I think they would be the appropriate people to put those questions to. My tenure was short indeed, and I have no difficulty if you raise anything in the context of my time there. So other than commenting that it's an enormously long time, I really can't comment about its status and the current status over that there. I think it's best to direct that to the ministers concerned. I'm not being dismissive or evasive, Advocate Vani.
Mr. Surti, thank you so much for your time and your endeavours to assist us. No further questions, Chairperson.
Thank you.
Good morning, Mr. Surti. I can't hear you.
Good morning to you, sir. Judge.
Yes.
Momo.
Yes. I must just be careful not to call you Surti because you are on
It's
first
Surti,
name
yeah.
terms, as you were a regular in my regional court 45 years ago in Rustenburg. And had also subsequently a few briefs from you. Mr. Surti, can we go, after these pleasantries, can we just go to back to your main statement, paragraph 6, and if you could read it into the record again, just to refresh our memories.
Paragraph 6, pardon, Judge?
Of the main
Of the
statement.
menu.
Of the main statement, yours.
Oh,
Yes.
okay, so sorry.
At 1747.
Would that be the memo of Advocate Mshare?
No, your statement.
Oh, my statement. So sorry
Yes.
about it. Pardon me.
Yes,
That comes with age. I'm sorry.
I agree. I know.
That would be during the same period. Are you talking about
Yes.
page 1747?
Yes.
Okay. During the same period, I served as programming whip in both the Senate and later the National Council of Provinces. I also served on the Rules Committee and Joint Rules Committee of Parliament, which were responsible for drafting the rules governing the Senate, the National Council of Provinces, and the Joint Rules of Parliament.
Yes. Now, you, the lead counsel, Advocate Semenya, broached with you the statement, the address to Parliament by President Mbeki in April 2003. Were you perhaps in Parliament during that time, and if so, did you listen to his speech?
Thank you, esteemed Judge. I probably was. I don't recollect missing a joint sitting of Parliament in the 25 years that I served as a Member of Parliament. But if you're going to ask me what were the joint statements in 25 years, because you get a joint sitting every year, and what was its contents, whether it's from President Mandela through the other presidents, it's going to be hard for me to recollect. Year 2003 is a long time ago. I probably would have been aware if it was just a year or two ago, but it's such a long time ago. So I'm not going to dispute that, in fact, it probably was raised and certainly would have been raised, but I wouldn't, I can't honestly say to you with the greatest of respect that I have a recollection of the detail, nor have I sought to ascertain what the detail was subsequently. So I don't have any knowledge, but I certainly do not dispute that the matter was raised as suggested by senior counsel.
Yes. Do I understand you that you have not refreshed your memory from this address by him to Parliament? This is by President Mbeki. You have not refreshed your
No,
memory.
I've not referred to it. It was not raised with me, Commissioner.
Okay. Okay, I understand. No, thank you, Chair.
Thank you.
Mr. Surti, thank you for your evidence and thank you for your many years of service to the country.
Thank you.
I just want to take you to the memo that was addressed to you by Advocate Mshe, specifically at page 1755.
1755. Yes, Council.
So, this was written on the 17th of February 2009. In the previous pages, Advocate Mshe lists the 9 TRC matters that are on hand. And in paragraph 4, he says, I quote, all of the above matters except for the PEPCO 3 case require investigations by SAPS before I can make a decision whether there are sufficient grounds to institute prosecutions or not. Now, your comment is investigations must proceed. So who would have been responsible for those investigations?
Thank you very much, and it's a very important and relevant question. As norm, South African Police Service would be responsible for the investigations, unless a structure, a dedicated structure is set up in order to assist and support and collaborate with the South African Police Service, as you would have in instances within the prosecution authority for commercial crimes, etc. So I'm not too sure what it was, but what paragraph 4 conveys to me is that in order for the National Director of Public Prosecution or the acting National Director of Public Prosecution to make a decision, he would require evidence through investigations to make an appropriate decision. And that probably, that could have contributed to my thinking. In any case, like I say, it's such a long time ago, I don't know what are the factors that all fed into my tiny brain at the time, but that could have been the reason why it was so important that investigations should proceed immediately, well, the emphasis there, in order that it would enable the National Director of Public Prosecutions to make a decision as to whether to prosecute or not.
Thank you. And therefore to exercise his constitutional powers.
Absolutely, absolutely.
Yes, thank you.
Thank you very much.
Thank
And
you,
thank you for
Mr.
your kind words too.
Mr. Siminya, any re-examination?
No re-examination, Chair.
Thank you.
Chairpersons, sorry to seek your indulgence. My memory has been jogged, and I did forget to put one matter to Mr. Surti. With your indulgence, may I put
Yes,
one
you may.
question to him?
1 point.
Mr. Surti, you've mentioned in your supplementary affidavit that apart from the memo, the TRC matters were not brought to your attention. The President, on the 21st of November 2007, he announced in Parliament a special dispensations on political pardons. And that was to assist those who had not applied for amnesty. It was put into practice in 2008, and then civil society organizations went to court in March of 2009 2009 to seek an urgent interdict to stop the political pardons going ahead, largely because victims and families were shut out of that process. And a judgment from Sariti J was handed down on the 28th of April 2009, just days before you left office. And he did interdict the president from proceeding. Do you recall that development? Because you, as Minister of Justice, you were cited in those proceedings.
May I respond?
Please.
No, thank you for raising the matter. As I try to try to give you the context, which is the existential context here. He is a man busy, very, very busy in education matters. He's called up in the afternoon, just during plenary, to say, you've been appointed now as Minister of Justice. I almost think it's a Wednesday or Thursday or Friday, whatever the case might be. I get sworn in the next day, I've got to go to the office. The first thing that's on my desk is in the media, and it's on the radio and television, there's going to be a national strike by prosecutors throughout the country. That was my first invitation to say, welcome to the Department of Justice. So at that time, those were the dominant things. And the Monday after that, calls came from the media regarding my Director General to say the Jinwala Commission had made a finding against him. What are you going to do about it? That's like 2 days in my office. The day after that, I received a call from I'm just giving you in context so that you can understand. I received a call from the acting Judge President in the Western Cape to say the esteemed Judge Klope has just rocked up in court to take over his position when he was on special leave. Now, just give you just an example of just 3 matters that were there on me immediately. Kind of just closed about everything else because those were all urgent matters. I couldn't delay the prosecution because our courts would have been without prosecutors and there would have been a national strike. I had to deal with the matter immediately. I couldn't delay the issue of the Director General because he would be in my office and I had to clarify how that would be dealt with, and I don't think it's really, if the Commission wants to hear how I dealt with it, I think I reflect on it in the affidavit, so I'm not going to repeat that there. And then the issue of the Western Cape Court. So that's within the first week itself. So there were so many aspects that were dominant, and then we had the application for pardon by one of the perpetrators. So it's just like one after the other, and you were so immersed in that and other work over there that if at all it was there, I was in education, probably paid less attention to that there. And I've indicated to you the task we had at that point in time. It was so immense, and I had a very, very hard-working minister at that time, Naledi Pandor, who had so much on her hands, and we just tried to pull together. So I'm saying to you, it happened so quickly that if it escaped me, I can only say I'm sorry, but really and truly, it didn't come to my attention at all. And I think it's just the circumstances, the issues that contributed to this pressure that made the kind of normal absorption of facts a bit more difficult.
Thank you. Thank you, Chairperson.
Thank you. Mr. Serti, we are profoundly grateful to you for having come to give evidence before this commission. You are now excused as a witness, and we thank you for coming.
May I thank the esteemed commission, chaired by yourself, lady, as well as Judge and Advocate Gabriel, as well as the team, Advocates Semenya, SC, and the representatives who are present here, and I hope I was able to assist the Commission in its task. Thank you very much for
Thank you.
your time.
These proceedings are adjourned until tomorrow at 10 o'clock.